I'm here today arguing on behalf of David Gore.
You're going to have to keep your voice up.
I always start off forgetting to raise that. I'm
You're
sorry.
such a shrinking violet.
I intend to focus my argument, to argue argument one, and in particular to be discussing Martinez v. Ryan. I'm certainly available to answer questions on any of the other issues in the case, but that's my focus. Martinez v. Ryan came out March 20th, and it's a non-capital case. And I view it as a tectonic shift in the collateral process.
Mr. Mclan,
yes.
There's no question. I agree with you, the statements in the brief that this certainly contains some broad sweeping language with regard to the importance of the work that you do in collateral review of these matters. But I do have some concern that our posture is so different in this case, and whether that the Martinez case, notwithstanding that language contains the qualifications, that it's really setting up an equitable basis to prohibit procedural bars for individuals going into the federal court system, and does not create a different landscape or a different prism through which we review these cases. Could you help, really address that part of this?
Absolutely, Your Honor. And I think to do that, I first want to start with the pre-Martinez landscape and how things have been for many years.
But we know how they've been. I think let's answer Justice Lewis's question, because I've read Martinez, we've all read Martinez, we know this case, we know that Gore had post-conviction counsel. We know that in Florida in terms of death cases is different than other states in terms of providing post-conviction counsel. And what I'm hearing you say is that you want to attack the 2007 opinion of this court based on the ineffectiveness of counsel back then. Is that what you, let's just get to how it relates here, what you're asking us to do.
We're seeking to present new evidence as to the ineffective assistance of resentencing counsel claim.
But whatever we think about Martinez, if the court bends over backwards any farther, it would have fallen over. It said no constitutional right to, we can argue about it, but in that case, counsel didn't present any arguments on behalf of the defendant. Is that correct?
In Martinez.
In Martinez.
In Martinez, yes.
And here you're saying that counsel in 2005 or 6 was ineffective in not calling or locating Nickerson?
Yes.
And so now, what about if you're ineffective in presenting what you're presenting here? Is there another? How would that ever be the law in this state as far as state cases, state post-conviction cases?
Yes, Your Honor. The point you're making is exactly the point that was made during the oral argument in Martinez, and the way it was resolved by the majority in Martinez was it's the initial review. We no longer separate according to direct appeal, right to counsel, collateral, no right to counsel. Instead, it's issue by issue under Martinez. If a state has taken an issue out of the direct appeal and moved it into the collateral process, ineffective assistance of counsel being the specific issue in Martinez, and put it in the collateral process, the U.S. Supreme Court was concerned with that strips the claim of the right to effective representation as to that claim. All that Martinez is addressing is the initial review. It's not saying, I have to be effective here today. It's saying the first time that the IAC resentencing counsel claim is presented in Mr. Gore's case, Mr. Gore was entitled to effective representation.
Well, let's just say, but now if you could go back to what Justice Lewis asked, it has nothing to do with the state court system. It has everything to do with the nightmare that's about to be created in the federal system, and I am really sorry for everybody that's going to have to deal with that decision. because it is sweeping, but it has, so far as I'm reading it, and I read it, it has nothing to do with what the states have an obligation to look at.
I have two responses. First, this court's decision in Lambrix is premised upon this court's understanding that the demarcation was a clear, categorical line, that you didn't look issue by issue. This court relied on Pennsylvania v. Findley and Murray v. Gerentano as having established that's the analysis. That's no longer true. That analysis is gone. The U.S. Supreme Court specifically in Martinez says, we took cert to address whether there's a constitutional right to have effective representation when raising a trial counsel ineffectiveness. We don't need to answer that question today in this case. So this court's conclusion that had already been previously resolved, that's gone. That's not true. The issue has not been resolved. The U.S. Supreme Court specifically leaves open whether or not whether the effective assistance of counsel in that instance is constitutionally mandated. What they said is all we have to do today is to find it equitably mandated because we're in the federal habeas context. And I think, so first, the basis for Lambrix is gone. Second, analyzing what it means, you've got to start with the ADPA in the mid-90s. Basically, the purpose of the ADPA was to give deference to this court, state courts' determinations on constitutional claims, to move the litigation into the state courts out of the federal courts. To some extent, Martinez is a carrot and a stick, saying if you want to keep it that way, then you should recognize the equitable right too.
But let me make sure that I do understand. But you are saying then that this now is a new right, whether you call it equitable or constitutional, because we do have our ineffective assistance claims addressed in post-conviction only, not on direct appeal. So therefore, that is now, will be in the future, a claim that will always be open because we always do it for the first time on post-conviction. Am I understanding you correctly? That's your position?
Yes, that Florida, like Arizona, has taken the ineffective assistance of counsel claim out of the direct appeal and put it into post-conviction. The court makes clear in Martinez that they're talking about the initial review of that claim. We're not talking about proceedings today. They are limiting it to the initial review because they're saying that that's in essence like the direct appeal, because it's the first time after the trial it gets addressed.
So let me ask you this. Is there a difference? Now, in Martinez, there was no ineffective assistance of counsel claim presented in the initial post-conviction, correct? Here we, of course, had an ineffective assistance of counsel claim presented. Doesn't that distinguish this case somewhat from the Martinez case?
Factually, it's different than the situation in Martinez, but the court in Martinez made it clear that that distinction doesn't matter, because they said it's not just the right to counsel, it's the right to have counsel effectively litigate the claim. And they said that the test, the yardstick for measuring counsel's performance in the litigation of the claim is Strickland.
Well, okay, but then the court also goes on, as I read this opinion, and it says it isn't just a matter of whether or not counsel presented the claim or presented the claim effectively. You've got to demonstrate also, in order to get to the cause, and still, I don't think you've effectively addressed this whole notion that this is addressed to the federal courts in whether or not they're going to find cause for his procedural default. That's what the Martinez case is all about, isn't it?
The court limited itself to that, leaving open the question of whether it's constitutionally mandated.
Well, whether or not they left something open, the real issue here is whether or not federal courts can find the cause element to overcome a procedural default. And not only the cause, but then you got to get to the prejudice aspect of it.
Correct, Your Honor. But let me just back up for one, because I'm making two arguments. One, that Pennsylvania v. Findley and Murray v. Gerentano, which were the basis of this court's ruling in Lambrix, don't say what this court thought they said. Martinez tells us so. So there is the question for this court to now address whether there is a constitutional right to effective representation, because that question has not been answered. This court thought it had been. It's now clear it has not been answered. Second, as to the cause, yes, the way that it works, and I think the way that it would work if this court were to recognize the equitable right, is you would present a claim that my collateral counsel failed to call the key witness to establish ineffective assistance of counsel.
Let me go to that, because I was mentioning 2007. That's when our opinion came out?
Yes, Your Honor.
It's 2012.
Correct.
Mr. Nickerson is a lawyer in Florida?
He's not practicing law now, and he lives in the Washington, D.C. area.
Somebody picked up a phone and found him in a matter of hours?
Yes.
And when did they do that? After the warrant was signed?
After the warrant was signed, after they learned that Udell had been disbarred, and the information regarding Udell.
And even under the jurisprudence you would ask this court to adopt, somebody could wait 5-10 years to whenever the death warrant is signed to attack the effectiveness of post-conviction counsel years before?
No.
Are you
I'm not making
serious?
that argument.
But that's what's happened here.
That's what's happened here because of one particular fact, the issuance of Martinez v. Ryan.
So your argument would be that Martinez, before Martinez, you couldn't bring this type of claim?
Before Martinez, Lambrix was the law.
But I thought you tried to bring, when was your post-conviction motion filed?
The original one?
No, after the death warrant.
It was filed after the death warrant in March of 2012.
But before Martinez?
Before Martinez, because Martinez, the oral argument had happened in October, so it had been granted.
And you don't think there's any obligation when you see that there is newly discovered evidence in a case that could make the difference between someone's life or death, that there is your obligation to still, you bring, multiple post-conviction motions to have brought that up in 2008, 2009, that there was not Mr. Udall, because it didn't matter what he has to say, that Mr. Nickerson needed to have been called. We said it in our opinion that he, did not testify. So if somebody looks at that and says, well, we got to get him to testify. We got to say, big mistake was made. We'd like him now to testify. Do you think you can wait 5 years to do that?
Not anymore. But the reason it was done in this case is because the law was clear. It didn't matter.
Well, the law, this court has never said, like say somebody missed a deadline by 1 day. This court has always used equity to make sure that a first post-conviction motion is heard. Can you think of one case where this court has not done that?
This court has used equity when it comes to the filing of a 3850, missing the deadline. That's what Steele v. Kehoe is about. That was adopted in 1999. And it's been limited, Steele v. Kehoe has been limited to either filing or not filing the 3850 on time. It has not been used to get around a failure to locate a particular witness as to an ineffective assistance of counsel claim. And in fact, that's what Lambrix was about itself. In Lambrix was alleging that CCR had been ineffective in the manner in which the ineffective assistance of trial counsel claim had been litigated, and asked that this court allow, in essence, a do-over. And this court said, relying on Pennsylvania v. Finley, no, it does not allow you to get around a procedural bar to say that your prior attorney had been ineffective.
And now you think the U.S. Supreme Court is telling state courts that there should be a do-over in every post-conviction case?
I'm not saying exactly that.
But it is, because you are exactly saying that.
That's certainly what Justice Scalia said, and that's why Justice Scalia dissented.
And I happen to agree with Justice Scalia in this case.
But what I am saying is the basis for this court's ruling in Lambrix is gone. This court has to revisit that issue. And
Mr. McClain, I just want to let you know you're now down to a total of about 5.5 minutes, so you're in your rebuttal. You may continue.
I appreciate that, Your Honor, and I would like to save the remainder of my time then for rebuttal. Thank you.
Good morning. May it please the Court. Silia Tenzio, Assistant Attorney General on behalf of the people of Florida. Justice Lewis, starting with your question, you're absolutely right. Martinez is extremely limited. And if it is to be a nightmare, as Justice Periente predicts, it's going to happen in federal court. It is limited to a state prisoner, a state prisoner bringing a federal habeas claim, and who then maybe will be allowed under equitable principles to overcome overcome a procedural bar through cause and prejudice. It has no bearing on what happens in this court. And as a matter of fact, this court, our legislature, the rule codified in 3850, our public records rule, Chapter 27, and this court's equitable powers have been in place for years and actually offers much, much more than Martinez would offer a federal habeas petitioner.
What about Mr. McLean's argument that the underpinnings of Lambrix have been damaged?
I disagree, Your Honor, because all of this is about the real question, and that is access to the courts. And if Lambrix was the end-all, then the legislature would not have established Chapter 27 to give the statutory right to counsel. This court would not have codified all the procedures that are already in place in 3851 regarding monitoring these cases, giving counsel as soon as a direct appeal is final, establishing public records procedures to enable post-conviction counsel to get those as soon as possible, to require trial courts to take the classes to be able to be death qualified.
Let me ask you this. I'm really concerned about Martinez to the extent that while the court says it's not deciding the issue of whether or not you should have a claim of ineffective assistance of post-conviction counsel, it seems to me by going through this mechanism of whether or not there is cause for procedural default, you are still in essence readdressing what the initial post-conviction counsel brought to the court. And so to some extent, it seems to me that statement they made really isn't true, and that we're going to have to be looking at what post-conviction counsel did.
You already do, but back to Martinez, it's the state's position that Martinez deals only with a claim of ineffective assistance of counsel that has never been heard by any court. The opinion says that twice, and when discussing whether or not they have overruled Coleman, they said they hadn't, because in Coleman, the issue had been already reviewed by a trial court. So we are not talking about what a post-conviction counsel had done with a claim on the merits. Martinez itself is about an Anders brief that was filed, and no court at any time will ever hear that issue. That is what Martinez is confined to, and even the cases cited in Martinez, Maples was an abandonment case, Holland was an abandonment case.
But that's where Mr. McLean is going. He seems to be saying, and then they do make reference to this issue approach, that where you push the issue with regard to the effectiveness of counsel, wherever it's first, at its first level, and maybe it's from the direct appeal as they're discussing it in that case, but in those systems that push it off, that there will be, that the right to have effective representation reviewed seems to be what they're saying.
But again, I think that is a concern for the states, or our state, and even in the majority opinion they talked about, well, we don't have to solve this problem, we don't have to require constitutional representation at post-conviction. They could have done that, and they didn't do that.
Well, I'm not concerned what they didn't do.
No,
I'm really concerned with trying to understand what they did do, and please help us with that, because they do talk about, in that opinion, the first time it's reviewed.
Well, in that sense, we are like Arizona. That's in terms of globally what the procedure is in Florida.
Right.
That yes, that is the first review. But again, I think it's limited to, not I think, I mean, it's clear from the opinion, it's limited to an issue, an IAC claim only, that has never been reviewed in any court ever.
What's amazing about this opinion is that the non-death cases, what they say in that opinion about prisoners who don't get counsel in non-death cases and may not know how to bring their claim. That is the other nightmare that the state, I think, is going to have to be dealing with as well as this court. But in this case, let's try to get to, let's just talk about this case.
Okay.
First of all, nothing about this is attacking the guilt phase of Mr. Gore and the murder.
Right.
So we're talking about the penalty phase. If we, since this is in this posture, without reaching the applicability of Martinez, can you make your precise argument with why, on the face of the record, no prejudice can be shown? Can you make that argument?
I can make that argument, Your Honor, based on this court's 2007 opinion and the trial court's order from the denial of relief. And on those specific 5 claims of ineffectiveness that were raised, this court found that in every single one of them, no prejudice had been established at the 3850 hearing.
But didn't we keep on saying, well, but Nickerson,
Yes, you
didn't
did.
testify? We said that like several times.
Yes, you did. And that's when you were discussing the deficiency prong. But this court also said in the same opinion that it's talking about, gee, I wish we heard from Jerome Nickerson. This court also said, but you know what? Basically, it doesn't matter because the evidentiary presentation you made at the 3851 would not and did not establish any prejudice, regardless if Nickerson wants to point fingers at Udell or if Udell wants to point fingers at Nickerson in terms of what was done, what was not done, whatever they did or didn't do, they still, at the 3851, did not establish that there was something different that would have ever made a difference.
Don't we also really have, despite what Mr. McLean said, also a procedural default issue? If we recognize that something terribly wrong went on at the post-conviction, we say we are dealing with a lawyer who was on the verge of a nervous breakdown or something. And we've sort of seen those kinds of attacks, and basically nothing was presented, and yet there was a wealth of new information that should have been presented. Don't we still want to say, if you look at that, you can't wait years. Now, Mr. McLean's, though, his argument is, I didn't know I could even bring this until Martinez was decided, which would have been, I guess, a week ago. But how do we deal with that issue?
Well, because Martinez isn't what would give him relief. Again, Martinez really has no impact in Florida. The impetus for this claim, as you said, Justice Periente, was your 2007 opinion. So the wherewithal to have brought such a claim, hey, we called the wrong guy, was back then.
But what he says is that there wasn't, we had Lambrick, so you couldn't bring a claim on that, yet he's actually brought it as a newly discovered claim involving Udall, which we have Curse case that was argued there too.
Right.
So whether Udall himself, by being disbarred, whether somehow that made him not a credible witness, right? So that's
right.
also the.
So the argument is that the legal underpinning, not the factual, didn't materialize until 3 weeks ago, and that is absolutely false. To find that, you would have to ignore Chapter 27, all the rules that are in place codified in 3851, and this court's equitable principles, and this court has never been shy to grant equitable relief in a particular case. We cited to Ventura, we cited to Coleman, in Kokol, in Peed, in Phototopoulos, so that it was always a legal avenue under this court's equitable powers, statutory powers and under the rule to address, so there has always been a legal vehicle to bring this claim long before Martinez came out.
If we just limit the approach in this case to prejudice, is that not tantamount to conceding that there is at least a viable claim, and we would have to look at every case that's ever preceded this for the prejudice analysis?
Well, I think that...
Isn't that what the result would be if we do this?
Well, again, that would be an alternative argument to so many before that.
I mean, I'm just trying to understand.
Yes, sir. As a matter of fact, our first argument still is today that there still is no constitutional right to post-conviction counsel, and Mr. Gore has not met the requirements of being able to file a successive motion. That is the thrust of our argument, our alternative argument, of which is one as a practical matter, but the state maintains that Martinez has changed absolutely nothing.
Well, but if we use equity, which is what the federal court used,
right,
there's no equitable principle here that would allow relief. And I guess, and again, the hard thing is to try to litigate this question. I mean, we're dealing with a man's life or death, but to see that nothing about Martinez has changed the death sentence and the confidence in the death sentence by what's been said. And I guess, and I agree that we've got to be careful, because we don't want to, I don't want to open the door to have, every time a Supreme Court opinion comes out, have what we've got now with the Walton series of cases, the Porter.
Right, under the Porter motions. You're right. And, Your Honor, again, not only has Martinez not affected anything, this court has always, under the state constitution, you could have done it then. But this court never has said it won't, because it doesn't want to open up the floodgates. And back to equity, equity requires requires clean hands of the defendant, and you can't get that. You can't get there in this case, as this court has, Your Honor, as you pointed out, they've waited 5 years after the signing of a death warrant to bring up this claim, and the legal underpinnings have always been available under the statute.
It seems to me that if we had even if in Martinez, that the party had waited 5-10 years.
I'm sorry, sir, I didn't hear you.
Even in the Martinez case, let's look at that one, that if the defendant had waited 5 years, I don't know that that's the basis. Would Martinez be different? Is that what you're saying? It
may be, because in the opinion itself, the United States Supreme Court mentioned that Martinez says he wasn't aware that there had been an Anders brief filed. Nothing had been explained to him. And in the oral argument, there was, in the rebuttal by Mr. Martinez, they mentioned that there was a language barrier between Mr. Martinez and his counsel. And as a matter of fact, in Martinez, it only has been sent back down to deal with everything that we're talking about. I mean, Martinez he didn't get relief. And the reason is because of Finley and Gerentano. The federal court said, oh, go away, we're not even going to entertain it. So now what the U.S. Supreme Court has said, under equitable principles, maybe possibly, maybe in this case, but we don't know, and that's why it was remanded. So I still think when you use the phrase equity, there is an obligation on the part of the defendant to come in with clean hands. So I don't think even under Martinez, in your scenario, I don't think he would get relief after 5 years.
But let me ask you this about the language in Martinez is really troubling. There's a section here that says where under state law claims of ineffective assistance of counsel must be raised in an initial review collateral proceeding. A procedural default will not be a bar to federal habeas court from hearing a substantial claim of ineffective assistance at trial if and this is the language, in the initial review collateral proceeding, there is no counsel,
Right.
or counsel in that proceeding was ineffective. So, you know, when you think about what it is that the court is actually going to have to look at, I mean, isn't that basically we're looking at whether or not post-conviction counsel was effective, at least in the context of an ineffective assistance of counsel claim.
You're right. However, I think what that means, and I'm basing, you know, my interpretation on what else the court said, and I think that is if a lawyer does not ever file the ineffective assistance of trial
I think
counsel
it could have
claim.
been so easy to put some modification in that counsel in the proceeding was ineffective. I don't see any place in this opinion where they actually do a modification of that phrase, and so that's what's troubling
on either
to
way,
me. Yeah.
you know, for or against, which, you know,
Well, I
either
mean,
interpretation.
if the court had wanted to stop there, because in this case, nothing was presented, the court could have certainly decided this case right there and not gone on, as she suggests, to use that. Or, like, you haven't provided counsel. In that case, they didn't make any claims.
But I'm not sure I understand the difference, because again, in that case, there was in essence, an Anders brief file said, there's nothing here, we don't need to go forward. And the court did say on 2 occasions, oh my gosh, if we let this go through, no court will ever have heard this claim. And I think it's important that they also said that's why this isn't Coleman, because in Coleman, a court had considered it. And I would also point this court to the Maples versus Thomas case that was argued the same day as Martinez and came out in January. And in that case, they talked about abandonment, again, abandonment of counsel, not following through with the claim. And there they said there is no claim of negligence of post-conviction counsel, but that didn't apply there because under agency law, he was abandoned. In effect, nothing was presented. And so I think there is enough, based on that context and on the context of the facts of Martinez, that this is limited to an post-conviction counsel being ineffective for not bringing the claim at all.
That's my concern, is that the phrase that Justice Quince read didn't say that.
But it didn't.
It said,
no, it didn't. You're right.
Right. It spoke in terms of ineffective assistance of that counsel.
Right, but you have to look at, I think, the context of Martinez when it was saying that. It was speaking, I mean, it's premised on the facts of Martinez, right? Mm-hmm. Okay, and there it was a complete, I mean, it was an Anders brief. So, I mean, it
just still seems that maybe the best way to go is this doesn't have application to what happens in this state, and let the federal courts deal with this, because the other case, Murray, was, to me, you know, these procedural bars for ADIPA are harsh, and there it was, the letter went to the mailroom, and then the guy didn't get to file.
in Maples, you're right.
Maples,
correct. Yes, correct.
You know, so whether it was called abandonment
Right.
or just pure neglect, I mean, I think that equity would have allowed in the federal court for that to be brought. So I think that I agree with you that this does not have application to a state court. I think our state court procedures are as good as or better than any, you know, state in this, you know, in this country in terms of what the legislature has provided and what this court has provided.
I would agree, and,
Well, I'm sure
obviously, but I mean, but also, I mean, we dare say that I don't think Martinez in the capital context in Florida could happen. So, based on our arguments, we ask that this court affirm the trial court's ruling in all respects. Thank you.
First, let me point, Maples was not about the initial review of an ineffective assistance of counsel claim. It was about the entire collateral process and included all other claims that Martinez doesn't apply to.
But didn't Maples apply to filing in federal court and missing the deadline.
Missed the notice of appeal deadline in state court. As a result, the federal habeas was untimely. And the U.S. Supreme Court found equitably he could go ahead and present it.
In federal court?
In federal court.
Nothing to do with the state
Doesn't
court.
have to do with the state court.
And in this court, if he had missed that deadline, we would, under all those cases,
Absolutely.
have let him file it, because that's what we do.
That is correct. But again, Maples is not about an ineffective assistance of collateral counsel claim. It's not. So Maples has nothing to do with the issue in this case. Martinez does.
How about Coleman?
Coleman v. Thompson came out in 1991. It was a missed notice of appeal in Virginia. And the U.S. Supreme Court said, too bad, you lose.
So what happened to, they didn't overrule Coleman. What did we take from that?
They said specifically in Coleman, they left open the question of effective representation on the initial review of an issue, a constitutional claim. And they specifically, that's what they rely on. They rely on that language in Coleman to say this question has never been answered, contrary to what everybody thought about Pennsylvania v. Finley and Murray v.
Well, if you're
Jones.
right, then I guess you'll have a federal district court to give you relief, because I just don't see without, frankly, and I understand you're advocating, I just don't see how we can have whatever they've said in that case apply and change the procedures in Florida. Most respectfully to you and to your advocacy.
First, I want to make the point that the state's position has an inherently inconsistent. First, the state says, Chapter 27, all these procedural safeguards are in play, so you could have done something. And at the same time, they're arguing there's no constitutional right and we should lose on that grounds, on the basis of Lambrix. The lower court relied on Lambrix. It can't be both ways. It can't be that we lose because the law says we lose, and it can't be that we lose because we should have known that the law really wasn't serious, that we had an equitable right, and we didn't do anything about it. I mean, when you're appointed on the registry, you have to justify the money you get paid for your hours. The state has taken the position that if we raise a frivolous claim that's clearly foreclosed, we're not getting paid, and we're going to get thrown off the registry. When it comes to Lambrix, the law could not have been clearer. In Lambrix, they were relying upon CCR's inadequate filing on an IAC claim. In essence, a shell motion. And Lambrix said, nobody ever came to talk to me.
I have never known you, Mr. McLean, again, I say this, that in respect for your advocacy, that if you think there's been an injustice to raise it as a newly discovered evidence claim, you continue to do that in Hildwyn, in Swofford. I don't think anybody is, maybe they've accused you of frivolous filings, but I've never known you to do that. So I don't think you would have been shy, I guess, in this case, in bringing something that you thought had been an injustice to Mr. David Allen Gore.
Well, again, the situation in 2007 was that the registry attorney who had failed to make any effort to find Jay Nickerson, which is classic ineffectiveness under Strickland, classic, was the one who represented Mr. Gore before this court and continued to represent Mr. Gore until the opinion came out. It was only after that that Mr. Batacola was appointed, and then it goes into federal court, and the issue is challenged in federal court. But due to the AEDPA deference was given to this court's resolution. Lambrix was clearly in place and clearly precluded. I tried to do that in Jose Jimenez in 2002 when I was appointed registry counsel and replaced the attorney who waived the IAC claim, and this court, in reliance upon what the state argued, dismissed it. Said I could not allege that the registry attorney was ineffective when he didn't investigate the IAC claim and waived it.
So now in every post-conviction motion, justified or not, you need to raise, it would seem to me, under this, you need to raise an ineffective assistance of counsel claim. And even if you raise the ineffective assistance of counsel claim, you better raise it effectively. That's, in essence, your interpretation of what Martinez says.
That's correct? My understanding of Martinez, and that Martinez, the issue is, after Martinez, when it's remanded to the lower court, has Martinez shown that the attorney who filed that Anders brief was ineffective?
And so, just a question on that. I see your eyes. And then would the state have to pay for the second or the third counsel to attack what the post-conviction counsel did?
Yeah.
Yes.
According to Martinez, yes, either the state or the federal government.
What if that counsel's ineffective?
This is the precise question.
That's the infinite regress.
Yes, this is the precise question that was discussed during the Martinez oral argument. And where do we draw the line was what the court was grappling with. And that's what Martinez is attempting to do. Your Honors, I think that this issue should be decided under the exigencies of a death warrant, because it affects not just Mr. Gore, not just people on death row, but all criminal defendants in the state of Florida. And for that reason, I would ask that a stay be granted and that additional briefing or amicus from interested parties, because this is all about what does Martinez mean in Florida. Thank you.
We thank you both for your arguments. That concludes this session of the court. All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.